The broadcast is now starting. All attendees are in listen-only mode.
Well, hello everybody who's listening to this UKIBC webinar. My name is Chris Hayes. I head up the professional services here for UKIBC, and I'm based in London. We have an excellent presenter for today, Atul Gupta, who's all the way on the other side of the living bridge over in Delhi. So he'll be going through the presentation for us, obviously on employment legislation in India. There's been some big changes recently, and obviously the Indian government is looking to reduce the amount of legislation in this area and bringing some overarching legislation. So Atul will run us through that, which will be fantastic. Just as a reminder, can all of our participants, both in the UK, India, and all over the globe, keep themselves on mute until the end of the session where we have questions and answers. You don't have to wait till the very end. If you, as we're going along, you have a question that you would like to pose to Atul at the end, you will see there is a questions tab on the right-hand side. Please feel free, type a question. We'll be looking at those and then we can put them through to Atul. So just to give you a bit of background, Atul has worked as a partner at Trilegal now for 13 years. He's an employment specialist with extensive experience and knowledge in India's vast labour and employment laws. He regularly works and advises clients on contract and policy formation, misconduct, white-collar investigations, sexual harassment matters, staff, and establishing restructures. So Atul, thank you very much for joining us, and over to you.
Thank you very much for that kind introduction. A very good morning, good afternoon, or good evening to everyone who's attending this session. I hope the next 30 minutes are productive and useful in getting you a little bit more familiar with what are recent developments and trends in Indian employment laws. Hopefully everyone can see the presentation that has been put up. Today's presentation is primarily going to cover the following topics: a quick introduction on the framework of Indian employment laws. For those of who aren't already familiar with the framework in India, or who are looking at India as a potential destination to do business in. We'll then talk about some of the some of the important changes that the government is trying to implement, including the new wage code, the industrial relation code, etc. We'll spend the last few minutes talking about a recent Supreme Court ruling relating to social security payments in India and certain compliances that clients in India seem to be grappling with when it comes to provision of creche benefits to employees. So let's spend a few minutes talking about what the framework of Indian employment law is. India is a vast country with several states, and employment law is a subject on which both our central government as well as the state government passes legislations on. Now, this slide has a description of just a few of the key central legislations that any organization has to deal with. So there is the Industrial Disputes Act, the Payment of Wages Act, the Minimum Wages Act, the Equal Remuneration Act, Standing Orders Act, Trade Unions Act, laws dealing with social security like the Provident Fund Act, Employee State Insurance Act, so on and so forth. There is a long list here with a brief description of the nature of the subject matters that they deal with. Everything covering from the subject of employee terminations, dispute resolutions, unfair labor practices, to detailed terms around how wage periods are defined, what are permissible payroll deductions, how minimum wages and overtime rules apply, workplace discrimination, service rules, trade union formation and bargaining, benefits, bonuses, contingent workforce, compensation for death, disability, so on and so forth. Now, if this is a handful, what you need to bear in mind is there are, apart from the central laws, there are also state-specific laws that are created by local state governments in whichever location that you might be running your operations in. And these laws add additional obligations and sometimes also overlap with the central laws. So the Shops and Commercial Establishments Act, for example, are pieces of legislation that every Indian state creates. And it talks about matters like leave entitlements, working hours, termination provisions again, deductions, provisions around women working in the night, security requirements, so on and so forth. There are the National and Festival Holidays Act, there is a Labor Welfare Fund law or a professional tax law. And apart from these unique state legislations, there are also rules and amendments that state governments create under the various central laws that we just spoke about earlier. Now, of course, this is just a bird's eye view of how legislation on employment works in India. The details, of course, can be quite more significant. But as a takeaway to anyone doing business in India, the key thing that organizations need to bear in mind is based on your location and the nature of your operations. On an average, you would easily find that you'll have to comply with about 15 to 20 different laws at any given point of time. And a lot of these laws have independent registration requirements, independent record keeping and filing requirements. So when you're looking at Indian labor and employment laws, you need to be mindful that there is a fair bit of time and effort that can be required to make sure that you're staying on the right side of the law and you're fully compliant with these legislations. Now, keeping in mind that there is a multiplicity of legislation, it's also important to understand if each one of these legislations apply to you. So there are various factors that have to be borne in mind while figuring out what laws apply and what do not. These are typically the remuneration of your employees, the number of employees that you have as an organization, the duration of service that your employees may have provided, the nature of your actual operations, whether you're a manufacturing operation or a commercial establishment, and the nature of the work that the employees do. So are they lower level employees? Are they in a supervisory role or in a managerial role? Right? All of these factors put together will have to be assessed to get a good sense of what laws actually apply to you as an organization or to your employees. And this homework is typically important at various stages because the thresholds can vary, both wage as well as employee headcount. Now, again, this is for the purposes of getting a bit more of color and context on what you need to bear in mind when you're looking at India and the framework of employment laws. The government at some level recognizes that this is quite complex, right? Having so many laws, having different thresholds, having different rules applying to different establishments, because of which over the last many years, there has been an active attempt by the government to try and streamline Indian labor laws. Towards that, the key and the most significant proposition is to create 4 labor codes, which would sort of amalgamate 44 different central laws, right? Now, these 4 codes are the Code on Wages, the Industrial Relations Code, the Occupational Health and Safety Code, and the Social Security Code. We're going to talk in a little bit more detail about the Wage Code and the Industrial Relations Code because those are the laws that are at the forefront right now. In fact, the Wage Code has gone through multiple levels of approval and is only now waiting to be notified. It's closest to being actual law. The Industrial Relations Code has been very recently introduced in the Indian Parliament. And the Occupational Health and Safety Code and Social Security Code are still in the works and are likely to take longer. But Let's talk about the wage code at this stage, right? If you can see on your screen, I've sort of summarized what are the key elements or key highlights of the wage code. The first thing that the wage code is doing it's turning the manner in which minimum wages in India are determined. Currently, unlike some foreign countries like the US, where there is a national minimum wage, India doesn't prescribe anything on those lines. Each state prescribes its own minimum wages, and those minimum wages are often very, very different based on the nature of the industry, the location, nature of skill, and task being performed. What the government is trying to do is propose a floor wage that would apply consistently throughout the country, with maybe variations based on geographical needs, but on the whole, the intention is that India would end up having a floor wage. A figure for this hasn't yet been prescribed, but what would happen once this floor wage is determined is that various state governments will have no flexibility to prescribe a minimum wage which is below this amount. What this is likely to do is achieve greater uniformity on how minimum wages are determined in India, and to some extent push wages upwards, keeping in mind what floor wage the government ultimately prescribes. The other key change that the wage code is prescribing is the threshold for applicability. As I was mentioning a few minutes earlier, a lot of the laws in India are only applicable to employees earning a certain amount of wages, and those who earn above the necessary threshold are often excluded from coverage under that law. The wage code seems to be doing away with these wage thresholds, at least in the context of certain provisions. The most significant of those which the current draft of the wage code suggests is that the thresholds of applicability for provisions that deal with deductions from employee wages, as to what are the potential deductions that an organization can make. For example, for loss to property, for any form of misconduct, for taking excess leave, so on and so forth. So those limitations were currently applicable only to employees earning up to a sum of INR 24,000 a month, right? Which is not a very big threshold, approximately 260, 300 pounds a month in terms of wages. It appears that the wage code is now trying to completely remove that threshold, and these wage deduction provisions would apply to everyone across the board. The other key changes are currently the law in India on equal remuneration and gender discrimination protects only women. The wage code seems to be making this gender neutral, which will require organizations to relook at how their policies are structured, how their wage practices are structured, and how they are going about things like recruitments, promotions, etc. Another key change is that currently under Indian law, organizations would typically face claims only from individual employees as compared to joint claims from a group of workers or employees. The wage code is now creating the concept of joint claims, which will have an impact on the manner in which organizations are likely to face claims. One key change that the wage code is proposing is the revision on the definition of wages itself. Currently, different laws in India prescribe different definitions of wages. So if you're trying to calculate someone's severance, if you're trying to calculate someone's leave entitlements, if you're trying to calculate someone's bonus entitlements, the components of wages that you would consider for each of these tend to vary from one legislation to another. And given that this is cumbersome, the attempt of the wage code is now to try and provide for a consistent or a common definition. What they have tried to do through this new definition is state that only basic wage dearness allowance and retaining allowance would be treated as part of the wages. And it has prescribed a whole list of exclusions, which are visible on the slide. Now, this is not extremely different from the current approach as well, although some of the changes that are being proposed are being questioned as being illogical. For example, a house rent allowance or the remuneration that a worker earns under an award or a settlement should not normally be treated as outside the scope of wages. But for some reason, that's what the wage code is proposing right now. So for example, if I am paying someone a house rent allowance as part of the salary, I cannot count that component as part of their wages to determine if I'm complying with minimum wage legislation. So this is a new development that is likely to impact organizations and how they structure their salaries. The wage code is not yet in force. It's waiting to be notified by the government. But as and when that happens, we are hoping that a few more rules and clarifications are likely to come out. And organizations will have a little bit more clarity at that point of time as to how best to structure their wage structures. One other important change that the wage code seems to be prescribing is heavier exposure to claims from workers. If, let's say, there is a shortfall in payment of minimum wages, if there are delays in payment of wages or overtime or bonus and so on and so forth. Previously, there wasn't any sort of prescription as to what kind of claim could be raised by the workers. Typically, a claim would be raised for the actual shortfall, and it would be to the discretion of the court to grant, let's say, some amount of interest or damages on top of it. Now, the wage code explicitly says that the compensation that could be claimed would be 10 times the default amount. So the exposure or the risk to organizations can go up significantly, coupled with the fact that there could now be joint claims from workers. What is another important change is that there has been an attempt to decriminalize some of the non-compliances under this law. Most Indian labor laws are quite difficult in the sense that any particular non-compliance, even if it's a trivial issue like non-maintenance of a particular register or some form of delay in making a filing, the potential penalty is criminal imprisonment. Now that's rarely ever awarded, but in theory, there is an exposure to your organization's management that guilty individuals could be imprisoned. What the wage code is doing is it's decriminalizing all first offenses and prescribing imprisonment only if there is a repeat offense of the same kind within a period of 5 years. It's further making it easier for organizations to deal with even a first instance of a non-compliance, whereby it's allowing for compounding of the offense. In other words, you could essentially enter into an agreement with the authority to pay a fine and not undergo a formal prosecution on account of the non-compliance. On the other hand, if there is a non-compliance and let's say an employee files a claim against the organization, the burden of proof has shifted onto the employer. It's no longer important for the employee to be able to gather up the evidence and demonstrate that he or she has suffered some form of detriment at the employer's hand. The employer is now required to demonstrate that it has indeed complied. And the wage code is also trying to make the whole system of audits and assessments by the labor authorities a little bit more streamlined and transparent. So those were the key highlights that apply in the context of the wage code. After the wage code, the most recent development has been on the industrial relations code. This was very, very recently tabled before the parliament, and it's probably one of the most important codes when it comes to labor and employment laws in India. This code attempts to amalgamate three laws: the Industrial Disputes Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. These legislations are all quite old. They go back to the time that India gained independence. And there was a significant demand that these be streamlined and be made a little bit more balanced in their outlook, because the typical grouse that industry has is that they are too employee centric and favor workers over the industry. Now, the IR code, or the Industrial Relations Code, in its current form is a mixed bag. It does tend to make some changes or propose certain changes which will allow organizations a little bit more flexibility in how they run their operations. So the first change that is being proposed in that context is greater and more formal recognition of fixed term employment, which means that it's going to be easier to hire individuals who will only work for an organization for a fixed duration, after which their employment would come to an automatic end, and organizations will potentially not have to deal with complicated rules and procedures to terminate staff. What unfortunately doesn't change is the need for organizations in certain sectors, typically factories, mines, and plantations, to seek government permission to retrench workers if they have 100 or more workers working in the establishment. Probably India is the only country which prescribes such a restrictive requirement, where whether it's a closure of the establishment, whether it's a retrenchment of a single workman, these types of organizations, i.e. factories, plants, and mines and plantations with 100 or more workmen, have to seek government permission to retrench their workers. So that has unfortunately not changed. I have that mentioned on a separate slide, but this was the sort of apt time to bring that up. So fixed term employment will hopefully make matters a little bit more flexible for organizations to, let's say, hire staff for periodic upswings in demand or periodic needs of a project-based work without having to worry about seeking government permission to let them go once the requirement comes to an end. The other change that will help create a slightly more, robust industrial relationship environment in the country, a little bit more transparent industrial relationship environment in the country, is introduction of formal provisions on union recognition and negotiating councils. Currently, there is no formal legislation in India which requires organizations to recognize a particular union. And very often there can be a lot of acrimonious battles on the legal front between representative of workers and management as to whether they have bargaining rights, so on and so forth. Hopefully these rules will streamline those industrial relations. Now, if there is only one union in an establishment, that has to be recognized as a negotiating union. Where there are multiple unions, the one which represents up to 75% of the workers must be recognized as the negotiating union. Where no union has 75% membership, the representatives from all unions with 10% or more membership have to form a negotiating council. So this is now creating a more formal mechanism around how you would end up dealing with trade unions. The Industrial Relations Code is also streamlining provisions relating to grievance redressal committees. For context, the older law also had a provision on grievance redressal committees, but it came with an exception which allowed employers who had independent existing grievance redressal mechanisms to avoid creating a GRC. Now that exception has been done away with. What this would mean is for organizations with 20 or more workers, they would now need to create a new GRC. And this GRC is not just going to be managed by the employer or the management itself. It will need to necessarily have representatives of both the management as well as the workers. So this is going to be a bit of a learning curve for organizations to get used to, because typically in the Indian scenario, it's quite uncommon to find such sort of committees where workers have a say in deciding the grievances of their fellow workers within the establishment. So this is an important change that organizations will need to be aware of. There are other changes which are positive. Strikes cannot be carried out by workers without a minimum 14-day requirement, which apply, and it only applies in the context of public utilities like gas suppliers, electricity organizations, so on and so forth. So for all establishments now, there'll be a little bit more predictability as to when workers are likely to go on a strike. The dispute resolution mechanisms under the Industrial Relations Code have been streamlined. Currently, there is conciliation officers, labor codes, tribunals, and multiple levels, which have been reduced to conciliation and labor tribunals alone. A conciliation has become time-bound, and older claims cannot now be looked at by conciliation officers, those which are older than 3 years. So hopefully this will streamline the process to resolve disputes if and when they do arise. There haven't been too many significant changes in other key provisions, the most important being the definition of who is a workman or a worker. The ITES industry has been demanding for clarity on it, but that hasn't come through. The wage threshold for supervisors to be considered as workers or not hasn't significantly changed. It was previously 10,000 rupees a month, which has now become 15,000 a month. As I was mentioning earlier, government approval requirements to retrench workers in factories, mines, and plantations has not been done away with. There has been no change in requirements to follow last in, first out rules for large-scale redundancies or retrenchments. There is also no clarity, unfortunately, on consent requirements associated with change of employers. India doesn't have rules on the same lines as you would see in the UK, for example, the due pay regulations. And there can often be ambiguity as to how you would deal with the workers when you're doing a business sale or an acquisition. And the most important of those is whether there is a need for consent from the workers involved. Unfortunately, the rules under the new IR code haven't been made any more clearer. The IR code is also now proposing a new reskilling fund, which essentially requires organizations to contribute 15 days wages to help in reskilling of retrenched workers, which is hopefully going to help them stand up on their feet sooner after they've lost a job. Now, moving on to the last two topics, which is the Supreme Court ruling on Provident Fund. As quick context, every organization with 20 or more workers needs to register under the Provident Fund Act and make mandatory PF contributions at the rate of 12% of an employee's salary. An employee has to make an equal 12% contribution through a payroll deduction. Now, there has been ambiguity for the longest time as to what components of pay should this 12% contribution be made on. Is it merely just the basic salary, or is it on a larger pay bracket including various guaranteed allowances? It's common practice in India to split the salary into a basic component and other allowances because there could be tax benefits associated with those other allowances. Due to this ambiguity, organizations very often have only paid Provident Fund on the basic salary. Due to this Supreme Court ruling, that practice is no longer considered as legal and valid. Due to this, organizations now have to start making Provident Fund payments on all guaranteed components of pay other than the basic salary, especially for those employees whose basic salary is below 15,000 rupees a month, because that's the threshold prescribed by the law. If you're not making those PF contributions on guaranteed components of salary, and your employee's current basic salary is below 15,000, then there is potentially significant exposure that you have. There is similar significant exposure when you're dealing with international workers, because the 15,000 wage threshold doesn't apply at all. Now, although this ruling came about in 2019, earlier in 2019, authorities potentially have the ability to go back to previous years and check if you've been compliant with this law for 2018, 17, 16, or earlier too. So organizations at this stage need to necessarily spend time taking stock of their pay structure and determining if they need to immediately revise their PF payment practices, and also understand what kind of exposure they may have to previous years. This is one legislation where we've seen that the exposure, financial exposure, can sometimes run into millions of dollars because of the size of the amounts involved and the fact that there could be significant interest and penalties on top of the basic contributions that organizations are likely to make. I'd like to spend the last few minutes on certain Creche rules that we've seen organizations grapple with before we open it up to questions. And so, as context, India amended the Maternity Benefit Act a couple of years ago, where it made it mandatory for all organizations with 50 or more employees, and not just women, to provide creche facilities. The act said that there would be rules that would be prescribed to, as far as what kind of distance the creche facilities should be within the organization or away from the organization, etc. Slowly but steadily, various governments are now creating rules to add further clarity on these creche rules. Karnataka, where Bangalore, the IT capital of India, has rolled out formal rules. Haryana, where Gurgaon is, has created draft rules. All these rules prescribe that the creche has to be within the establishment or a maximum of 500 meters from the entrance. They prescribe detailed rules on the amenities that have to be provided, what kind of staff have to be arranged, including things like mandatory monthly medical checkups for kids, etc. These creches have to be provided for children right up till the age of 6 years, right? So it's not just recent mothers or people who you anticipate are on their path to motherhood, but even potentially older employees who've been in the organization and who have children up to the age of 6 years who can insist on having access to the creche facilities. Now, the rules are unfortunately silent on whether it's possible to do a cost sharing. I mean, does the creche facility have to be entirely borne by the establishment? Could you have employees pay for a portion of the cost or all of it, so long as you're footing the cost to create the facility? There's no legal clarity on it, although the Ministry of Labour seems to think that it has to be a cost borne by the employer. Unfortunately, there is further ambiguity, which at least some of the rules are creating. For example, the Karnataka government uses the term mother and parent quite interchangeably, which makes it unclear whether the creche facility needs to be provided only if I have women workers who have children, or do I even have to provide a creche if I'm, let's say, an organization with only male employees, or running a shift which is only comprising of male employees, maybe during the nighttime hours? Do I need to then extend the creche facility during those hours or only to male employees? And how do I do it? Because in India, there are very limited, there are lots of limitations around me operating any sort of facility during the nighttime hours or hiring women employees during nighttime hours. And all these creche facilities need to necessarily be staffed by women workers. So these are the ambiguities that the creche rules are creating, which can create significant operational constraints. And it's a key area where organizations are now currently trying to grapple with and try and make some sense as to how to comply with these rules. So that sort of brings us to the end of today's session in terms of what I was hoping to cover. I'd be more than happy to take questions from the attendees.
Atul, a huge thank you for that very insightful presentation. That was really useful. I found a lot of areas there which sounded very excellent in terms of India's want to climb further up the ease of doing business survey. I think that's an area where UKIBC is working quite hard with, and I guess as people start to send their questions through, and just a reminder, anybody who wants to send a question, please just click on the questions tab. So we've got a few that have already come in, so we'll put them to you, Atul. But just before we do, obviously I'll take Chair's prerogative. So I mentioned there about the Ease of Doing Business survey, and UKIBC has just released our recent report. 59% of the people surveyed stated that the legal and regulatory position in India is one of the biggest barriers. You mentioned there that companies have to look at adhering to 50 to 20 laws, and you also mentioned that there was the Indian government is looking to reduce 44 central laws down to 4 codes. What do you think is the time frame for that, and do you think that will have a significant impact in terms of India trying to achieve top 50 place in the world rankings of ease of doing business next year?
Sure. So the time frame, frankly, is very difficult to predict at the moment, but I think the government is making quite good progress since the Modi government has come back into power for the second time, and based on the kind of majority that they enjoy in our parliament, they have the perfect opportunity to push through these legislative changes. So in a very short time frame, now we have seen the wage code being approved, only waiting to be notified, the industrial relations code being tabled before the parliament, and there is fast work happening on the other codes as well. My sense is over the next 2 years, we would have at least some of these codes implemented, and the others achieving greater finality in the form and shape to be implemented. So 2 to 3 years is the time frame that I would give for potentially all of these codes to be implemented and replace those 44 laws. To answer the second part of your question, do I believe that this will help India climb up the ease of doing business rankings? I believe it will. Apart from the fact that it is trying to make India a more investor-friendly location and trying to, decriminalize petty issues, there is also an attempt to move towards things like digitization of record keeping, online portals where inspections and assessments can be tracked in a more transparent manner, a consolidation and overall reduction in the type of filings and records that an organization needs to maintain. Of course, because of the fact that India is a jurisdiction where both central and state laws apply, this exercise is only covering the central laws. It's not necessarily touching upon the state laws. So that level of duality will remain. But we would certainly be in a better position as compared to before once these codes come into play.
Perfect. Thank you very much for that. So we've got a couple of questions coming in. So we've got a question here from Sindhuja. He said, would you refer joint claims as class action, or would this be different from a class action? So
India has historically not had any sort of class action lawsuits, especially in the context of labor claims. I would say that this is coming as close as possible to a class action lawsuit. There is a specific form prescribed under the wage code whereby multiple workers can come together and file a claim jointly saying we've not been paid minimum wages, we've not received overtime, or we've not received our wages on time. So yes, it is indeed now in the form of a class action where a class or a group of employees can come together and file a claim. Now, what used to happen previously is one individual workman might come forward and say, listen, I haven't received minimum wages. Maybe 2 would or 5 would, but each of these would be individually dealt with. So the ticket size of each claim would be small, and organizations have the freedom to sort of negotiate with each of these individual workmen independently. Now, because of these group claims, the ticket size of the claim is increasing. And on top of that, the compensation amount that could be awarded could be 10 times the default. So you're potentially now looking at a very different risk profile for the same non-compliance that you previously had. So yes, so that's the key change that organizations will need to be mindful of.
Right, thank you very much. Because we've got another question in it that says, are the Supreme Court rulings retrospectively applicable? It's important to understand this to ensure compliance with the same. We have noticed that there's various notices were issued to the entitleds claiming that they are not complying with the SC rule. If the ruling is retrospectively applicable, how long back would one have to trace the applicability to?
Sure. So this is a very, very important issue that organizations are dealing with. For further context, the Supreme Court ruling right now has essentially interpreted earlier Supreme Court rulings from the 1970s and in a way upheld an earlier position. So the view of the Provident Fund Department is that, you know, this new ruling is merely clarifying what we believe was an existing position of the law. It's not really changing the narrative. As organizations, you chose not to comply with the earlier ruling on the grounds that there are various appeals pending before the court, etc. But because of the fact that this is essentially a reiteration of the earlier position, we believe that we have the ability to go back to prior years. Now, a review petition was filed before the Supreme Court seeking clarity on this exact same point. Unfortunately, that review petition was thrown out by the Supreme Court saying that there is no merit in it. So if I were to answer this simply, the answer is that it is retrospective. The exposure is potentially going back beyond just the date of this ruling. Currently, there is no limitation period prescribed under the PF Act, although recent amendments, draft amendments rolled out by the Provident Fund organization are prescribing a 5-year period. That is not yet formal law, but we anticipate that that would end up being the case. We have in fact seen assessments in connection with international workers, i.e. people who are expats and foreign passport holders, go back right up till 2008 because that's when those provisions were introduced into the PF Act. So even today, you could find that the PF department is asking you to show compliance with international worker related provisions, maybe dating 10, 11 years ago. That still happens. We address these types of issues for our clients quite often. Practically, for organizations in India, the wage threshold was revised to 15,000 rupees per month from September of 2014. I would say if you're trying to figure out your exposure for past years, at least go up till September 2015. Before that, the wage threshold was a much smaller amount of 6,500 rupees a month. And the exposure in connection with that is potentially much lower. So I would say at least go back to September 2014 and take stock of whether there is any exposure in from that period onwards at the very minimum.
Perfect. Thank you very much. So just one quick question from me. You mentioned there about, or you mentioned in the presentation about different states having different legislation. So how do you and Trilegal go around advising, say, for instance, a UK business that's looking at setting up in India so that they understand where would be the most appropriate state for them in terms of sort of employment legislation?
Yeah, so, the laws vary from state to state, but the variations tend to be under state-specific laws on matters like leave entitlements and more nuanced benefits like access to professions tax or payments of labor welfare funds. If you are an entity looking to set up shop in India, I would say the state level variations in these benefits should be something that you should take note of, and we at Trilegal have the ability to advise across all Indian states. We have offices in multiple states and are licensed to operate in all states, but the overarching factors to my mind should not just be these state level differences in the law, but better access to a trained employee work pool and access to better regulatory mechanisms. So, for example, Karnataka is a state which is inviting or trying to actively invite ITS companies to set up shop.
Yeah.
It's referred to as the Silicon Valley. And that's a state where, therefore, they've granted a lot of exemptions to IT industries in terms of working hours, in terms of allowing women to work in the night, in terms of exemptions from laws like the Standing Orders Act, right? So we can always assist organizations if they are trying to determine where they would want to set up shop and give them a quick comparison of what are the key differences, which would help them form a better decision.
Perfect. That's great. And that sort of ties nicely into our Ease Doing Business report as well, where we've started to look at a state-by-state level to be able to give businesses an idea of which of the states are easier to do business than the others. Unfortunately, we've run out of time, so there were a few more questions, but unfortunately we've run out of time. So what we'll do is we'll pass those questions on to Atul, who will no doubt reply to them. As you can see, we've got our Twitter handles there, so we are at UKIBC. Please feel free to follow us to get all the updates on everything that we're doing, all of our events and activity in the UK and, of course, over in India. And, of course, Atul is from Trilegal at Trilegal Law. Please feel free to follow those guys as well. They do amazing work. Got great coverage all over the India, and we are very proud to have them as a UKIBC member. So on that note, very good afternoon to you all, and good morning, and thank you very much for joining this UKIBC webinar. Atul, thanks very much again.
Thank you. Thank you so much for organizing this. Everyone have a great day. Thanks for your attendance.